Jake Curtis from Institute for Reforming Government is standing by to talk about the latest. The WEC kicked the can, and now we have the fast track at the Wisconsin Supreme Court. What shenanigans are we seeing already, Jake?
Hey, Vicki. Thanks for having me on. Yeah, this is definitely moving quickly. That's one of the things we have to keep in mind with these election-related matters. Anytime there's election-type litigation, there's always going to be really tight timelines. So things are moving very quickly. So, we actually spoke last week on air, and at that point in time, as you noted, there was a complaint filed with WEC, the Wisconsin Election Commission. And in fairness, they probably did the right thing in that they were named. And so obviously there's a conflict there. So they basically indicated that they couldn't hear the matter. I think you and I also discussed, I'm not sure they really would have had jurisdiction to do so, right? WEC is the entity that typically reviews challenges to nomination signatures. Here, this is really a statutory challenge. And so, that would have been an interesting kind of development, but essentially what happened is they dismissed the complaint on Friday. So that was last week, Friday. And so this Monday, the DNC, and we have to be clear here, right? It's the DNC. Technically it's an individual, but in his capacity as, I think it's like a deputy director of the Wisconsin DNC, has essentially filed a complaint. It's an original action with the state Supreme Court. And just so everybody understands, typically, right, you have litigation that starts out at the circuit court level, and then whoever loses that case has the right to appeal that to the Court of Appeals, and then whoever loses that decision can then appeal to the Wisconsin Supreme Court. Right? That's the basic kind of litigation process. There is an ability of a complainant to essentially ask the court, the Wisconsin Supreme Court, to take the case.
Right.
Called an original action.
I think most people understand. Yeah, most people get that. Yep.
Right. So that's what happened on Monday, and now we are in this kind of insane timeline where essentially on, I believe it was Wednesday or yesterday, the court ordered that the DNC actually identify who was representing the Green Party, which I don't want to say it's completely unprecedented. I'm sure there are situations where maybe that has occurred, but it certainly is very odd, right? So essentially the party that brings the case is then ordered to then find who's representing the entity that they are suing, which is very odd. And then the court has ordered the Green Party and then any other interested parties to file responses by 5 o'clock today. So what time?
Wow. So Will or IRG, if you wanted to file a response, if you got till 5 o'clock to join the case?
5 o'clock. 5 o'clock.
So
two hours. My understanding, and there's just lots of chatter out there, is that there probably will be an entity that is going to be filing a response. I am hopeful that happens because I was involved in the 2020 challenge, and the Green Party is a third party. Now, obviously, I don't agree with them on much of anything, but the reality is, there's an important point here, and this is why IRG and Will and others are, we don't do partisan politics, but there's important principles here. Look, if an entity goes out, I don't care if it's the Green Party, I don't care if it's the Constitution Party, even if they're drawing from, obviously the Constitution Party probably draws from conservatives. The Green Party obviously draws from Democrat candidates. But the reality is, if an entity goes out and has volunteers getting signatures, and I was at the 4th of July parade in Cedarburg, and I believe it was the RFK campaign actually, came up to us and asked if we wanted to sign. We didn't, but, good for them, right? They're out there sweating, trying to get signatures to get their person on the ballot. If they get the requisite number of signatures, Wisconsin law is pretty clear that outside of, material deficiencies in those signatures, or we've had cases where campaigns pay the same groups to go out. We had that in Milwaukee County, right? Outside of those kind of legal deficiencies, if you get the requisite number of signatures, the candidate should be on the ballot.
Right. So how is it that the Supreme Court, the liberal majority of the Supreme Court, ordered the DNC to identify the Green Party's representation?
Well, good question, Vicki. I mean, clearly, right, with procedural
how is that even their right to do that? And why wasn't the Green Party able to represent itself and say, hey, don't do this?
Another good question. I don't know kind of what the Green Party is up to. I certainly hope that they participate and defend their right to be on the ballot. I mean, courts have a lot of discretion to manage a case, but it's not my opinion. I mean, look at there was a dissent. Justice Rebecca Bradley, filed a dissent both. So there are actually two orders. The order relating to the DNC identifying the Green Party representative or counsel, Justice Rebecca Bradley dissented to that and noted how, let's just say, it was odd. And then I would really encourage people to read her dissent to the order to file responses by 5 o'clock today, because I think she does a very good job. It's a short, page dissent where she basically points out, right, there are other deadlines at play here. There are internal, she notes an internal deadline where the other justices, right, should have the opportunity to review filings. I believe it's 2 days. So she noted, the majority on the court has essentially ignored its own internal deadlines for the other justices to review filings. And then just as a standard litigation practice, right, counsel for parties that are named in litigation should have the right to review filings in a timely manner and then respond according to deadlines. And, theoretically, the court can set the deadlines it wants to, but to give a party barely 24 hours to respond to, I believe, a 15, 20-page complaint. I mean, I've been involved in litigation.
Wow.
I know I've been on your show that litigate, and this is not an email, right? This is a very technical filing, responding to statutory, arguments, code arguments, case law.
Right, and you can't just say this is all crap. We're challenging this. You have to respond to the actual order itself. I've only got 2 minutes left, Jake. When is the deadline to print ballots in Wisconsin?
So my understanding is so there's a couple key deadlines. So good final question. I believe next Tuesday or Wednesday, WEC actually meets to finalize third-party candidates. So that's the key deadline. I guess presumably the court would have to have some decision by then. And then September 18th is the date when county clerks send printed ballots so most county clerks are the ones that are actually managing and printing the ballots. Those are then sent to the municipal clerks, and then the municipal clerks have to start sending out absentee ballots by September 19th. But obviously, right, we're talking tens, hundreds of thousands of ballots that have to be printed. This is not a short process.
So WEC has until Tuesday or Wednesday of next week. What is that a statutory deadline?
I believe so. I mean, right, because
okay.
Right, you have to work backwards from these September dates, right? So county clerks have to have direction. I mean, they don't decide themselves who's on the ballot, right? That's an order or
right.
Some sort of submission produced by WEC, so that then the clerks know who to put on the ballot.
This is going to be shoved down everyone's throat by Tuesday. That's what I think. Jake Curtis,
Yep,
Institute for
right.
Reforming Government. I good to have you on the program. I appreciate the information. Thank you.
Thank you.